Hey there, everyone. It is Rob Ryder on Sunday, May 4th, 2014. Going to be talking about the federal question jurisdiction. And basically, the definition of that is in the United States law, federal question jurisdiction is the subject matter jurisdiction of the United States federal courts to hear a civil case because the plaintiff has alleged a violation of the United States Constitution, federal law, or treaty to which the United States is a party. And so the federal courts got subject matter in certain areas like civil rights, and a federal law or a treaty, as far as that goes, is something like an act of Congress. It can also be apparently it looks like it can be a presidential executive order. And there have been some written that are really good for us. So we're going to look at the federal question jurisdiction and how it came about and how we can try to use it and how it fits into what you need to do per these different acts that we've been trying and where those stand. And see if we can find any remedy. And I am Rob Ryder. My email address is courtofrecord@aol.com. Phone number 616-712-6179. Donate, please, if you can. Can't pay the rent. It's already late. It's already, what is today? The 4th. I'm 4 days behind. Please help out if you can. PayPal name is ashleyritluski@gmail.com for PayPal, or you can send it in the mail to myself, Robert Ritluski, at 10955 14 Mile Road, Rockford, Michigan, 49341. And thank you. Okay. So, in looking this stuff up, I didn't plan to do a bunch with the Northwest Ordinance. That wasn't what I was looking for, but ended up looking at a bunch of things to do with the Northwest Ordinance and these other acts at the same time. And it doesn't take long to figure out there never really was a state of Ohio. And people have said it before, but I'm going to do a whole video just on that, just because I think it's very interesting, the legacy that was left behind. But nevertheless, the District of Ohio was a federal judicial district of the United States created by the Federal Judiciary Act of 1801, which consisted of the Northwest and Indiana territories. So they had taken the Northwest territory by this time, and they had split it in half and made the Indiana territory on half of it. Actually went right through the middle of Michigan, and the other half was still called the Northwest Territory. Okay, but the original Northwest Territory was this whole piece of land, and they split it in half and still called one the Northwest. But so this District of Ohio made the entire thing the original Northwest Territory, called the District of Ohio. And when you read the Northwest Ordinance, it was only supposed to be split once into half, and that was the split. And then later on, though, they made the state of Ohio and took the top half of what would be the eastern half of the Northwest Territory and gave it to Illinois. So they didn't follow what it said to do in the Northwest Ordinance, and in fact there was never an act of Congress that ever made Ohio a state. And in like 1953 they had a referendum to pick a day back in 1802 to say, well, that was the day we became a state, because they never were made a state. But this all was part of this Judiciary Act of 1801, and that's what we're going to look at now, because it did some other things besides make this district. Because this act was only in force for like 1 year. So the Midnight Judges Act represented an effort to solve an issue in the United States Supreme Court during the 19th century. There was a concern being in 1789 about the system that required justices of the Supreme Court to ride circuit and reiterate decisions made in the appellate level courts. So in other words, the Supreme Court judges were supposed to be riding horses all over God's creation in their circuit. And they didn't want to do that, apparently. So the act reduced the number of Supreme Court judges, blah, blah, blah. In addition, creating new lifetime posts for... Now this is interesting. In addition to creating new lifetime posts for Federalist, it doesn't say federal, Federalist judges. And then when you look at the history of the Northwest Ordinance when all this was going on, there were two parties. There was the Federalist and another group called the Republican Democratic Party. Go figure. That's a party. Republican Democratic is a party. Right? We're in a one-party system right now. One half is called Republican, the other is called Democrat, but it was one party back in the day, and it still is one party. But this created posts for these lifetime posts for Federalist, which is the other party's judges. So I don't know what that means, but it didn't say federal judges. The circuit judgeships were intended to relieve the justices of the Supreme Court from the hardships of riding circuit. Okay. In addition, it gave circuit courts jurisdiction to hear all cases in law or equity. Well, hang on now, because equity is chancery. Right? So cases in law and cases in chancery. And equity is justice. Cases in law, not necessarily just, depends on how the law is written. Cases of equity, where if the law is against you, for instance, the law says he who holds the title is the owner, and somebody steals your title out of your house, then they can say, well, I'm the owner, I got the title. And equity would say, well, you got it by fraud, right? But the law would say, well, you're the owner. If there wasn't equity, law would give the title, give the property to the person with the title in their hand, even if they got it by fraud. So, it gave circuit courts jurisdiction to hear all cases in law and equity arising under the Constitution and laws of the United States and treaties made or which shall be made under their authority. And from last week we saw that the letter from the nuncio in the United States, that they were making a comment that for 181 years the Supreme Court of the United States of America has considered as self-executing treaties all acts of legislation, acts of Congress. It's a self-executing treaty. Right, so the circuit court now has jurisdiction to hear all cases in law and equity arising under treaties or these acts of Congress. This form of jurisdiction was known as federal question jurisdiction, had not previously been granted to the federal courts. Right, so basically that some things are by the jurisdiction is determined by the law that was written, if it gives subject matter to it. See, this was during the waning Federalist Party and the rising Democratic Republican Party. Maybe they called themselves the Whigs, I don't know, but I didn't know until just here recently that there was actually a party at one time called the Democratic Republican Party. And that's what we're seeing today, in my opinion. We're only ever seeing one half of this system working. I don't plan on reading this whole thing, but anyways, Marbury Madison has something to do with it. I'm going to have to read that someday, but that wasn't the main thing. The main thing is federal question jurisdiction. Article 3 of the United States Constitution permits federal courts to hear such cases so long as the United States Congress passes a statute to that effect. However, when Congress passed the Judiciary Act 1789, which authorized the newly created federal courts to hear such cases, it initially chose not to allow lower federal courts to possess federal question jurisdiction. But now, in 28 U.S.C. 1331, it now gives this. The district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. Unlike diversity jurisdiction, which is based on the parties coming from different states, the federal question jurisdiction no longer has any amount in controversy requirement. Congress eliminated this requirement in actions against the United States in 1976 and in all federal question cases in 1980. Therefore, a federal court can hear a federal question case even if no money is sought by the plaintiff. Right? You're just pointing out a crime. They're using color of law against me. To meet the requirements of the case arising under federal law, the federal question must appear on the face of the plaintiff's complaint. Right? So what's the federal question? To me, that's going to be the act that you're using, right, to give them jurisdiction. Federal question jurisdiction no longer had any amount of controversy requirement. Beautiful. There has been considerable dispute over which constitutes a federal question. In these circumstances, now settled law that the plaintiff cannot seek the jurisdiction of the federal court merely because he anticipates the defendant is going to raise defense based on the Constitution or on a federal statute. Well, that wouldn't make any sense. They don't want you to go there, to the federal court, because that's where you can bring it up. This well-pleaded complaint rule has been criticized by legal scholars, blah, 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 blah. But as it turns out, we're going to have a much easier thing to do. Or so it looks. So what is federal law? It consists of acts of Congress, treaties ratified by the Senate, regulations proclamated by the executive branch. I would say those are executive orders. And case law originating from the federal judiciary. So I would say that's whatever the Supreme Court's decided on a case. That those are the things: acts of Congress, treaties ratified by the Senate, executive orders, case law out of the federal courts is federal law. And as long as you're bringing those things up, you've given the federal question jurisdiction, the answer it needs. There's a federal law that says it can't do this. I'm bringing it to this court. All right, so you can't bring state law to them, and you can't bring, I don't think you can probably bring codified law to them, but we're going to find out. But you can certainly bring acts of Congress. Right, so there's a lot of civil rights acts that have been written. Those are all acts of Congress. They're considered self-executing treaties by the Vatican, and they're considered federal law by the United States. Federal laws and treaties, so long as they are in accordance with the Constitution as well as the Constitution itself, preempt conflicting state or territorial laws in the 50 states and in the territories. There's no rebutting what is the supreme law. It's the federal law. Only the limited supreme authority enumerated in the Constitution. Okay, otherwise state law is, because they're sovereigns, right? The state law would apply, but only in the limited supreme authority enumerated in the Constitution. And those are such things as needful rules enacted by the Congress. Well, that's what an act of Congress is. It's a needful rule. Right. Just real quick, maybe you may want to Google this: the Four Doctrines of Self-Executing Treaties by Carlos Manuel Vasquez, where it says a distinction has become entrenched in United States law between treaties that are self-executing and those that are not. Apparently there's a difference. Identify these four doctrines as reflected in self-execution decisions of the Supreme Court and lower federal courts. At a general level, a self-executing treaty may be defined as a treaty that may be enforced in the courts without prior legislation by Congress. Okay, a treaty may be enforced by the courts without prior legislation by Congress. What do I mean by enforced by the courts? I mean enforced in our domestic courts, whether state or federal, at the behest of individuals. Although treaties, as a matter of international law, are thought to confer rights only on states, domestic law regulates the legal relations of individuals vis-a-vis other individuals and governments, and the purpose of our domestic courts has always been thought to be the vindication of the rights of individuals. Not a sovereign, not sovereigns. See, Marbury versus Madison. All right, so we're talking about your individual rights, the vindication of your rights, and that's what it was called in the in the Act of 1863, the Vindication of Rights. It was the 1866 Civil Rights Act that gave the remedy of the vindication of rights, which says, right, that you put a petition into your court case to say, hey, move this to federal court because you're using color law against me in as defined by the Civil Rights Act of 1866. Sorry about that. Let's see what else was on here. These are just little detail things, but So the reason, so this is what they're saying, basically, there's the supremacy clause in the Constitution, and it is the legislation that allows these self-executing treaties to be executed without any other legislation. You got all that? Congress passed a resolution in the waning days proclaiming that treaties were binding and obligatory on states even without implementing legislation. But this position was controversial, and in any event, the federal government lacked a mechanism for making state courts enforce treaties. You can have the law, but how are you going to make us enforce them? And that's how we end up to where we are today. You know how they do it? It's because all these organizations have taken federal funding. And because they've taken federal funding, they can't discriminate against you. And so what you're supposed to do is, if you believe you're being discriminated against, like in court, right, because you can't find justice, what you ask them for is you ask them for their federal funding sources, because you want to put a complaint into them. We'll look at that deeper in a second, but just little things that where this is leading to. So the clause addressed the treaty violation problem by altering the British rule. It declared treaties to be the supreme law of the land, right? There we go. The supreme law of the land are treaties. Acts of Congress are considered self-executing treaties. They are the supreme law of the land. There's nowhere else to go. It doesn't matter 18 USC, no codified law, no state law, no nothing. In the republic or in the federal government, the highest law there is are treaties. They're the supreme law of the land. And they consider an act of Congress to be a treaty. So, okay, I got to switch pages for a second. Hang on just a second here. Okay, just to recap. So, I started really with the Civil Rights Act of 1866, maybe 3-4 weeks ago. So you'll find a video on it back there. I go in a little more detail, but what it did is it furnished the means of vindication of your rights, right? Protect all persons, individuals, and a way to vindicate your rights. And let's see. It gave the jurisdiction to the district courts of the United States. Because by this time I think we'd gotten rid of the circuit courts, and now we just had district courts. We used to have circuit courts. We still have circuit courts. Lowercase circuit courts. You know, when you read lowercase circuit court in your state law or in a federal law, to me it's the same court. Right? It's like the court in the republic. Instead of the organized court or incorporated court. But what it did is it incorporated another act that allowed you to remove, for any reason whatsoever, to remove such cause for trial to the proper district or circuit court in the manner prescribed by the act relating to habeas corpus and regulating judicial proceedings in certain cases. It's the name of the act. And that's the act that has the remedies in it. And it was further enacted that the district attorneys, marshals, deputy marshals of the United States, the commissioners so appointed by the circuit and territorial courts, with powers of arresting, imprisoning, and bailing offenders against laws of the United States, right? So we're looking to say, okay, well, we need to find these people because they're the ones that have the power that they can, I believe if we go on further, we're going to see they can take our commissioners are hereby authorized and required to exercise and discharge all powers and duties conferred on them by this act, right? So they were like magistrate judges, for lack of a better term. And they were within their counties, respectively, right? Said commissioners, right? So we had these federal officers called commissioners living within counties, had the same power as a magistrate judge does at a district court right now. Who is it? And the person so appointed to execute any warrant or process as aforesaid shall have authority to summon and call at their aid bystanders, posse comitatus, the proper county, blah, 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 right? Really got the same powers as the sheriff. So, so that's the other thing. Now, who has those powers today? Because they don't. get rid of the powers, they just hide them. But now we get into, here's the act, right? The act relating to habeas corpus and regulating judicial proceedings in certain cases. And this is talking about during the ongoing rebellion. During the present rebellion, right? So this was during the Civil War. They said there was rebellion going on. There's never been a peace treaty. Rebellion's still going on. This law is still in effect. And this talks about how habeas corpus could be suspended. But if it's suspended, then they have to have a certificate from the president for the prisoner. And they're also going to make a list of state or political prisoners. And somehow we've gotten our name on this list, right? We're on this list of state or political prisoners, and we've never gone to ask for a discharge. Right? So here's one of them. You're supposed to, it shall be the duty of the judge of said court forthwith to make an order that any such prisoner desiring to discharge from said imprisonment be brought before him to be discharged. You're walking around on a prison planet. You don't need to be behind bars to be imprisoned. You're in a gaol, G-A-O-L, form of prison where, you're just out in the countryside fending for yourself. But you're still, we have a civil disability. Basically, we're, illegitimate. That was the first problem. And from there, they've had all sorts of other things, like enforced disappearance of your person. No person shall be discharged by virtue of this act until he or she will have taken an oath of allegiance. So you're going to have to take an oath and say, hey, I'm not the problem, right? I'm a peaceful inhabitant. And then it goes on to say that any order of the president under his authority made at any time during the existence of the present rebellion shall be a defense in all courts, right? So this is where an executive order is part of the federal law. And in any suit or prosecution, civil or criminal, has been or shall be commenced in any state court against any person, right? File a petition stating the facts and verified by affidavit for the removal of the cause to a trial in the next circuit court in the United States to be holden in the district where the suit is pending. The duty of the state court to accept the surety and proceed no further, right? So what this says, you put a petition in your court case. Now we got to make sure that gets done right, but that's what it says to do. And as it turns out, Roe tried it, and we'll talk about that in just a minute, where that sits. But I'm trying to find the part that if you don't and it shall be the duty of the person taking such appeal to produce the file, the said court, circuit court, attest copies of the process, right? So when you put this in, somebody's got to get an attested copy, put it together, and take it to the circuit court. And the circuit court shall thereupon proceed to try and determine facts and law and such actions as if it had originally started in that court, from the start. So, provided, however, that if the party aforesaid shall fail duly to enter the removal and transfer, as aforesaid, in the circuit court of the United States, agreeably to this act, the state court by which judgment shall have been rendered, and from which the transfer and removal shall have been made, as aforesaid, shall be authorized on motion for that purpose to issue execution and carry into effect any such judgment. Blah, 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 blah. In other words, if you don't ask to have it moved, right, then you agree with whatever judgment the state's going to give you. And provided also, and if in any suit hereafter commenced the plaintiff is non-suited or judgment pass against him, the defendant shall recover double cost. Right? So you're still the defendant, you're just moving the case. Now if the plaintiff doesn't try his suit or is found to be in contempt of court for committing fraud by, no sworn complaint or whatever the hell it's going to be, you're going to get double cost. But you have to ask to move it. So here's an act that says, here's your remedy, America. Are you going to use it or not? or you're going to decide you got to try to do some other way because it's just too fucking, this isn't hard enough. You can't write a short petition, put it in a court case, and expect something to happen. That's possibly true. But we tried it, and we're going to see what happens. So, give me just a second here again. Okay, and we also had the Fugitive Slave Act of 1850. That talked about one of the things it was going to do, that the Superior Court of each organized territory of the United States shall have the same power to appoint commissioners to take acknowledgments of bail and affidavits, take depositions of witnesses in civil causes which now possessed by the circuit court, blah, 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 blah. All right, so here's these commissioners again. We got, the commissioners were established by an act of Congress that they could be appointed. So, they have to be there someplace. It's further enacted that the commissioners above named shall have concurrent jurisdiction with judges of the circuit district courts of the United States in their respective circuits and districts within the several states. Now see, this is proper circuit and district of the United States, and this is common or lowercase circuit and districts within the several states. Well, we have several circuits within Michigan, right? I don't know how many there is. There's 83 counties. I don't know if there's 83 circuits or not, but 15th Circuit Court, right? 16th Judicial Circuit. So there's all sorts of circuits. So, so the commissioners, whoever these commissioners are, in their respective lowercase circuit and district, have the same power as the judges, concurrent jurisdiction with judges in the proper case circuit and district. So it doesn't sound like the case has to necessarily move, and this is what this is coming to. When I had told Bobby about this week, he had talked to Patrick, and Patrick remembered his mother had a court case where she owed $10,000, or that's what they were saying, or whatever, and he was new at this and just trying to put things in. But he noticed that as he put different things in, they changed the name on the court. And one of the names it went to, it started out as like the City Court of Prescott. It ended up being the District Court of Prescott. And in that court, if I'm not mistaken, is when the judge just asked his mother, well, would you be willing to pay $2,500 instead of $10,000? And she said yes. So that was the conciliatory answer. They reconciled it. Okay, pay $2,500. You okay with that? Yep. Okay, everybody's happy. All right, case over. That's equity or whatever. She could have said, well, I just do not pay any, judge, until they can show me a contract that they've signed that I owe them anything. And of course they can't. And he would have said, well, you got no contract. She's right. So the point is, the same court, which was basically the traffic court, which, that's very well could be the guy who's called the office the recorder. In New York, they often hear traffic cases and murder cases, right? The highest level cases, and the rest of the time they sit in traffic court. And they can wear different hats. So, alrighty, we're gonna. Okay, but there was another thing. And upon satisfactory proof being made, a positive affidavit in writing to be taken, certified by such court judge or commissioner, by satisfactory testimony duly taken, certified by some court, magistrate, justice, peace, legal officer, an oath, and take depositions under the laws of the state or territory from which the person owing service lever may have escaped. Long story short, they can take your oath, right? Take your complaint. These commissioners can, or whoever they're putting in those positions, with a certificate of such magistracy. You don't see the word magistracy used very often, but there it is. That's imperial power. Not imperial, but hierarchical power for sure. Oh, so anyways, these acts either give the remedy or give the players that are going to invoke the remedy, and we just need to figure out who they are today. That's where we're at right now. So, okay, all that leads us to one place, to the Civil Rights Act of 1964, where they set up this commission that we'll take a look at. But let's look at the duties first, right? What were the duties of the commission? Investigate allegations in writing, under oath or affirmation, that certain citizens of the United States are being deprived of their right to vote. I've talked about this numerous times. We're supposed to be registered electors, and they're not letting us do that. Now, there's people who got a problem with the voting thing. That's fine. Keep it to yourself. Let's go on. Study and collect information concerning legal developments constituting denial of equal protection under laws, Constitution because of race, color, national origin, right? Of the laws under the Constitution or in the administration of justice. Serve as national clearinghouse for information in respect to denials of equal protection of laws because of race, color, religion, national origin, including but not limited to the fields of voting, education, housing, employment, the use of public facilities of transportation, or in the administration of justice. So we're supposed to be given this commission, which is I can't remember the name of it, but it shouldn't be that hard to remember. Civil Rights Commission, I think, is what it is. We're supposed to be giving them our complaints. Right? Title V, Commission on Civil Rights. Now, one of the things in the same act is Title VI, which says that you cannot be discriminated against by anybody who takes federal funding. And it gives the example that if one prison takes federal funding for some kind of system in their prison, now the whole prison system is included under that umbrella. That's how the federal government got the power to enforce these treaties now, because if you take federal funding, you've already agreed, you consented to the jurisdiction. And now they can go enforce the law. We just have to go and tell them to go enforce it. The Commission shall separately state and currently publish in the Federal Register descriptions of its central and field organization, including the established places at which and methods whereby the public may secure information or make request, statements of the general course and method by which functions are channeled and determined, rules adopted as authorized by law. No person shall in any manner be subject to or required to resort to rules, organizations, or procedures not so published. Whatever's published is how you invoke it. And I haven't gone to look at it myself yet. That's where I'm headed to next. Well, later on today. Each member of the Commission who is not otherwise in the service of the government of the United States shall receive the sum of $75 per day. So each member of the Commission who is not otherwise in service of the government, like somebody who's been deputized, right? So they can deputize people. There's their duties. And then the other one is, and these things are so long, Title 10. They're all interesting. Title 6 is good because that has to do with the federal funding. But as you can see, there'd be no way to go through this. So there shall be hereby established a Department of Commerce, a Community Relations Service. It was under Commerce, and now it's moved under the Justice Department. It shall be the service of the function to provide assistance to communities and persons therein in resolving disputes, disagreements, or difficulties relating to discriminatory practices based on race, color, national origin, which impair the rights of persons in such communities under the Constitution or laws of the United States, or which affect or may affect interstate commerce. Okay, so these places have, they're listed on the Justice website, and their function, I gotta move this down here, provide assistance to communities and persons therein in resolving disputes, disagreements, or difficulties relating to discriminatory practices based on race, color, national origin, and as it turns out since then, anything to do with a hate crime, which impair the rights of persons in such communities under the Constitution or laws of the United States. Right? So that's the treaties and the acts of Congress. Or which may affect interstate commerce, right? Your ability to contract. The service may offer its services in cases of such disputes, disagreements, or difficulties whenever it is in judgment, peaceful relations among the citizens of the community involved are threatened. Right? Because it said one of the things about this discrimination is it can be a neutral, what appears to be a neutral requirement that ends up being discriminatory to one group or another. And I would say that's what it is, like how you're supposed to put a motion into a court or put paperwork into a court case. It's neutral. You both have to do it the same way, but they didn't tell you how to do it. They told them how to do it. And they're just not going to look at your paperwork because you're not putting it in right. Well, that's discrimination. That's, I'm trying to get the administration of justice. So we got this group here, and we had the other group was called, what were they called again? The Commission. The Commission. Commission on Civil Rights. All right, the Commission on Civil Rights is the clearinghouse for information in respect to denials of equal protection. Blah, 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 blah. So it's either you take it to this commission or you take it to this conciliatory group, and I really believe this is the group that we're supposed to take it to, and the other one is the one that kind of runs the show, because this is the legislative mandate for the Community Relations Service. Director shall be appointed for a term of 4 years. Well, that's how long it was for magistrate judges, marshals, commissioners. I think they all had 4-year terms at one time. It shall be a function of the service to provide assistance to communities and persons therein in resolving disputes, disagreements, difficulties relating to discriminatory practices based on race, color, national origin, or impair the rights of persons in such communities under the Constitution. See, it says or national origin, which impair the rights of persons in such communities under the Constitution or laws, blah, 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 blah. And then they added the hate crimes to it. And somehow they get involved in
Avast virus database has been updated.
Tribal law enforcement. Offenses involving actual or perceived race, color, religion, or national origin. Right? Hate crime stuff. Assist state and local units of government. Well, you are a local unit of government, right? One man, one vote. You are the government. If you look at the way that a flow chart is supposed to be like for a township, it's the electors on top and then the board underneath. And you're supposed to be a qualified registered elector, and they're not allowing you to do that. If you did, you could tell the township to go pay the bills and get the frickin' township out of bankruptcy. Because there's nobody there to tell them to pay the bills. All the offices are vacated. It's a hell of a system. Once they got it set up, they just closed the door and walked away. Okay, hang on a minute. Alright, well, all that was to lead up to this. Here, a couple of weeks ago, we put a petition into Roe's case. This is based on the Civil Rights Act of 1866, which said to put a petition in the case. So, I, Rosita, the petitioner, state that the following is true to the best of my knowledge and belief on or about the dates of, in the County of Kane, in the Northern District of Illinois, a simulated legal process, and then she put the number in, using color law was initiated against my person in violation of acts of Congress as well as Title 18 United States Code. Now, I didn't mean, when I sent this, I had these things read because they were going to have to all be changed, and apparently she didn't change the color. No big deal. that's what went in there. That's what the reason they're red. They were things that may need to change depending on who was doing it. So, so the Civil Rights Act of 1866, inclusive of an act relating to habeas corpus and regulating judicial proceedings in certain cases, incorporated by reference, define color law process as a form of enslavement and allow any case started in local or state court to be removed to Article III trial court of the United States, where both fact and law will be examined. Fully described in Section 5 of the Act relating to habeas corpus, blah, blah, blah. So go look at the Act, right? You go look at it. Because I don't know what the exact words are. I don't even know if it should be called an Article III court. I'm not sure if it should be called the district court, the circuit court. I'm not sure what to call it. What I know is I'm trying to invoke Section 5 of an act of Congress, and, for you not to follow it, whoever that is, that would be an act of treason. They're self-executing treaties. It's the duty of the United States District Judge to discharge any prisoner, because it did say so, requesting discharge be brought before said judge for the execution of discharge, administering of oath to enter into recognizance with or without surety, and the sum to be fixed by said judge or court to keep the peace and to be good behavior towards the United States and its citizens. I accept the oath of the United States District Judge, bind the occupant to it, and remind them of their fiduciary duty to discharge, and request said hearing and memorial to the event be certified by the court. I will also require the assistance of the federal marshal to register as a qualified elector within my ward republic by affidavit. Now, this was written a couple weeks ago before reading all this other stuff here recently about the newer act, but we're going to go with this one because it's still an act of Congress. And so Roe went and did this, and she went to the window at the court that says traffic criminal, because it's a criminal case that she's involved in. It's disturbing the peace by asking at the clerk's office why they're charging her $40 when it says that it should cost $6 or something like that. And just asking the question was enough to be considered disturbing the peace. Right? Simulated legal process. But Roe took this down there, and she didn't have this, and she said, I need you to swear me in, take my oath. And the guy didn't know what to do, so he went and got a supervisor and came back. She said, you're going to have to use Thomas's seal. Right, so we got two things going on here. We got this is the circuit clerk right here. Now that isn't who did it, right, but that's who it is. Now the problem with this that I can see is it doesn't have the name of the person that did this on there on behalf of, like the deputy clerk. I don't know if it matters or not, but because at the end of the day, although it's really hard to see, maybe you can see this line right here. This has got a court seal on it, an embossed court seal. That doesn't happen very often. Rose said it never happened before. In any paperwork she put in, they never put a court seal on it. 16th Judicial Circuit. See, here we go. 16th Judicial Circuit. Kane County, Illinois. That's what this seal has on there. Hartwell, Circuit Clerk. Not Circuit Court Clerk. Not Clerk of the Circuit Court. The Circuit Clerk. So that was what we put in, and then she did an affidavit of mailing, and she hadn't heard anything, so she just now this was right around the Easter time and so forth, lots going on. So here last week she finally got a hold of Thomas Hartwell by email, and he emailed back, your petition for vindication of rights has been received in my office and filed on 4/22/2014. It has been placed in the court file case 13 CM 3431. Now that doesn't have any spaces, dashes, hyphens, nothing extra. Not 2013. We've seen cases like that before. That's what they usually do. They put a 2000 in front of that 13, or they don't put a 2000 in front of the 13. I don't know. I did a video month or so ago, showing stuff with Jerry. This was the videos I had to do with it's all about elections and that these people aren't elected. And it had a petition that had a 0 as like the fourth digit in a court case that had a dash as the fourth digit in. Right? So they were using different numbers, and so I believe that they're using a different number here, but it has been placed in court file, case number. Well, let's go see it if it's been put in there. She didn't get a file copy from him. Where's a copy with some kind of a indication number on it? Anyways, your next court date is 5/15/2014 at Kane County Branch Court. See, they don't use, I don't even know if this is a real date, right? Can you do it this way? Does that count? It doesn't say 2014. 14 what? At Kane County Branch Court at the north end of my building, blah, blah, blah. Okay, your address. You may address the judge at that time. So, of course, 15th is a bit of time away, and we don't necessarily want to wait. So Roe is going to email him again and say, well, that's fine, Thomas. What I need to know is this now in a federal court under federal law, or if not, I'm going to need the name of your federal funding sources to put in a complaint. Well, that's where we were, and then some more reading over this weekend. Oh, it looks like we can go to this office within the Justice Department that's supposed to handle this kind of stuff. Irregardless, the petition was put in, and she got this response from Thomas. So, and she had done an affidavit of service. So normally that's what they put on, something like this, right? This little file thing here. But apparently this has got a court case, or I don't know if this had a court seal or not. If she said it had a court seal, I believe she said that it did. But you can see they're not using the same. Because now she sent it to the clerk of the circuit court, because that is his other, right? That is one of his hats, is the clerk of the circuit court, compared to circuit clerk. Clerk of the circuit court. Circuit clerk. Circuit clerk, get the seal. Clerk of the circuit court, get no seal. They did get his name. Now, I don't know if she did this in front of Thomas Hartwell. No, I don't think she did. I think she just took it to the same window, just to have it put in a court case. So, anyways, that's where that's where all this is now. He got it. He admitted he got it. He said he put it into a court case. Called her Rosita. That's good stuff. I just need to find out, okay, are we on the right path or not? Now, the other thing to do is get a hold of the office through the because they have an office in Chicago for this, not the commissioner, but the community organizer. Like community organizers, I don't believe that's what they are, but that you're supposed to go to if you believe that you're not getting proper administration of justice because somebody's using color of law against you. It's really that simple. All right, I got to switch things one more time. Hang on a second. Okay, we're looking at Civil Rights Act of 1964 again, Title VI, Non-Discrimination in Federally Assisted Programs. No person in the United States shall, on ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Again, so if they're receiving any kind of federal funding, and it doesn't have to be money, it could be equipment, it could be computer help, it could be all sorts of things. They've made themselves beholding to the federal government and all the laws of the federal government. So that's how the federal government got jurisdiction over them, through all the agencies in the state that it didn't have when it first employed these things back in the 1700s. Didn't have any way to make them follow a treaty. Well, now they do. Now they have their consent to the agreement. So this act then became basically, looks like Title 42 of USC Section 2000. A, B, C, D, E, F, G goes on up, right? Federally assisted programs is this particular section. It talks about the same thing. So all they did is they codified the Civil Rights Act, defining what federally assisted programs are. Compliance with any requirement adopted to this section may be affected. Termination or refusal to grant or continue assistance, right? So that's what they can do, how to get compliance. Termination of the grant or any other means authorized by law, provided that no action shall be taken until the department or agency concerned is advised, appropriate persons or persons, of failure to comply with a requirement that is, right? So there you go. Leadership and coordination. And listed some things there. The Attorney General shall coordinate implementation enforcement by executive agencies, various non-discrimination provisions of the following laws: the Civil Rights Act of 1964, any other provision of federal statutory law, and that is a act of Congress which provides in whole or in part that no person in the United States shall, on the ground of race, color, national origin, handicap, religion, sex, be excluded from participation in, be denied the benefits of, or subjected to discrimination under any program or activity receiving federal financial assistance. The court's taking money, then they have to administer justice equally. If they're not, then they're guilty of discrimination. Right? So this is for anything, right? It says any other provision of federal statutory law which provides in whole or in part that no person in the United States shall, on the ground of race, color, national origin, handicap, religion, or sex, be excluded from participation in, denied the benefits of, subjected to discrimination under any program or activity receiving federal financial assistance. See where it says handicap here? They're going to change that word eventually. It's going to be, what do they call it? Disability. And we all have a legal disability. We're civilly dead because we were born bastards. Right? They put your mom's name down in her maiden name and your dad in his name, and that's an indication they're not married. So says the Catholic Church. And that was, the last video I did. And more on that here, another video separately, but there's just too many things to cover at one time and any one thing. So done with that one. Done with that one. Here's an example of what the EPA says, because this federal funding, what it said in this video that's on the Justice Department about Title VI of the Civil Rights Act, that if you have a complaint against an organization, you go to them and you ask them for their federal funding source, and they have an obligation to tell you who it is. And so I think you would do that by putting in a FOIA, asking them for it, because now if they don't give it to you, well, now you have evidence they didn't, and you have a reason for a court case, and now it makes sense. Now you're going to take it to this community regulator people, and they're going to get involved. External Compliance and Complaint Program. The External Compliance Complaint Program is designed to ensure recipients of EPA financial assistance and others comply with the relevant non-discrimination requirements under federal law. So Tom, out in California, the water man, right? You got the Clean Water Act. This is how you're going to get it enforced, by the EPA. When a complaint of discrimination is filed with EPA alleging a violation of something, because these, in Tom's case, these sewer districts are taking federal money, but they're not following the Clean Water Act, well, they're in violation of the act. They're breaking the federal law. So then you take it to the EPA on a complaint for civil rights violation because you're being discriminated against. In fact, on the EPA site, they have a place to put in a complaint for things to do with the air and stuff. And I'm going to go back and look at that closer, put one in for the chemtrails. So the EPA's program to implement Title VI of the Civil Rights Act 1864. Now this is on the EPA site. If you were to Google EPA and civil rights, you'd find it'd take you to a page on the EPA's website for civil rights, and they got a lot of information there. So, but one of the things is that Title VI authorizes federal agencies, including the EPA, to adopt implementing regulations that prohibit discriminatory effects as well as intentional discrimination. Frequently, discrimination results from policies and practices that are neutral on their face but have the effect of discriminating. Facially neutral policies or practices that result in discrimination effects violate EPA's Title VI regulations unless it is shown that they are justified and there is no less discriminatory alternative. Again, I'm thinking of court, right? That we're going into a court not understanding what the rules are, and nobody wants to tell you what the rules are. You're being discriminated against. They can't give legal advice. Whatever. Title VI allows persons to file administrative complaints with federal departments and agencies alleging discrimination by financial assistance recipients. Now this just isn't the EPA, this is broadly speaking of all of them. The Office of Civil Rights has responsibility within EPA to process and review Title VI administrative complaints. So they have an Office of Civil Rights in the EPA. There you go, Tom. Office of Civil Rights, EPA. Put it in. Let's see what they do with that one. Other improving access to services for persons of limited English. Executive order. Okay, they got all sorts of executive orders that, right? Because these executive orders, again, these executive orders are part of the federal law. Leadership and coordination of implementation and enforcement of non-discriminatory laws, Executive Order 12250. 12630, governmental actions and interference with constitutionally protected property rights. And, well, this is why I was talking about, I put this note for myself. The narrator in the movie said recipients are obligated to send people to the right place to file complaints. Meaning you were going to go there and ask them, hey, who is your funding source, your federal funding source, so I can put in a complaint. That's going to really frost their cake. Voting section enforces the civil provisions of the federal laws that protect the right to vote, including the Voter Rights Act, Uniform and Overseas Citizens Absentee Voting Act, National Voter Registration Act, blah, 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 blah. See, one of the things they're not letting us do is register in the jurisdiction we desire to register in. They're making us register in a jurisdiction we just as soon not be in. But you need to register. Right, so you can say, I'm over here, see, here's the record, I'm registered in this jurisdiction, I'm not part of that jurisdiction, I don't consent to the jurisdiction. But you have to pick a jurisdiction because the civil authority is a divinely appointed office. So pick the one that, works best for you. If you don't plan on harming anybody, what do you care, right? You just want to not be harmed. Lowercase federal. And if it isn't there, then it's the church, and it's either the state or the church. Either one's going to go to the church. So I don't know that this voting one came off of the EPA. I was just putting stuff on paper. Just to show, though, that there are executive orders that, could be used to your benefit. I don't know how we search executive orders, but I can say this, that they are part of the federal law, and there's an agency that's been set up to frickin' enforce them. Dear Rosita again. Hate crime. Whoever, whether or not acting under color of law, willfully causes bodily injury to a person through the use of fire. Right? What do you mean? I'm fired? What kind of fire? Firearm? Dangerous weapon? To me, a pen is a dangerous weapon. Or explosive or incendiary device. Attempts to cause bodily injury to any person because of actual or perceived race, color, religion, or national origin of any person. Well, I'm a Christian. I believe I'm being persecuted by people that have Judeo-Christian beliefs and for whatever reason don't think they need to have a sworn complaint to take my property. Right? That they can use a simulated legal process and color a law. That's discrimination. All offenses involving actual or perceived religion, national origin, gender, sexual orientation, or disability. Right? You're civilly dead. You're a bastard in a system of Jewish law. You're born a bastard. We're going to invoke that Old Testament on you. Even though Jesus said the law and the prophets ended with John the Baptist, they still want to use them. In general, whoever, whether or not acting under color law in any circumstance described in some other paragraphs, right, disability of person, circumstances described, yada, 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 right, using a channel, facility, or instrumentality of interstate or foreign commerce. All right, so if you're using the bank, or you're using whatever would be a facility of interstate commerce or instrumentality, pretty much everything, because everything's a business. And because of your disability, somebody takes advantage of you, well, that's discrimination. It's a hate crime. All right, it's a crime against humanity. We're not talking 1 to 5. Right, we're talking crimes against humanity. They may even have a death sentence for that. Simply because you're trying to use an instrumentality of commerce and somebody takes advantage of your disability, your religion, your origin, whatever, to take advantage of you, that's discrimination. It's a hate crime. Otherwise affects interstate or foreign commerce. If it affects commerce, man, it's a hate crime. They're doing it against you. Offenses occurring in special maritime or territorial jurisdiction in the United States. Bodily injury means a cut, abrasion, bruise, burn, disfigurement. Physical pain. Physical pain's about illness. Those things are bodily injury. Right? If somebody stresses your ass out, that is physical pain. At least it was for me. Impairment of the functions of a bodily member, organ, or mental faculty, or, right, so if they coerce you, that's messing with your mental faculty, right, coercion, duress, then that's a bodily injury. Any other injury to the body, no matter how temporary, it's a bodily injury. If somebody injures your body, it's a hate crime. They put them handcuffs on too tight. It's a hate crime. Right? So what we need to do is take these complaints to the right offices. And give me just a second. I'll go get that sheet again. So I think the place we're supposed to be taking our complaints to about this civil rights violations is to Community Relations Service, where it says the mission of the Community Relations Service is the department's peacemaker. All right, well, blessed are the peacemakers. They call themselves a peacemaker. That's very interesting. That's biblical. The Community Relations Service is the department's peacemaker for community conflicts and tensions arising from differences of race, color, and national origin. Created by the Civil Rights Act of 1964, CRS is the only federal agency dedicated to the assistance of state and local government, private and public organizations. With the passage of the Hate Crimes Prevention Act, it also works with communities to employ strategies to respond to alleged violations of hate crimes. That sounds like the right place to get a hold of. and point out to them that it's a matter of discrimination against the Civil Rights Acts, and you're not being given access to administration of justice. And then show them the evidence we've talked about: simulated legal processes, complaints that weren't signed, lack of a warrant, no abstracted title or no abstracted judgment forwarded to the state agency, that the people that are holding the state offices that you're going to the court for aren't elected. All sorts of things are discrimination. These are the guys supposed to investigate it. You just need to give them the information. The CRS lends its services when requested or accepted by the parties. Right? You got to request it. The service uses impartial mediation practices and conflict resolution procedures to help local leaders resolve problems and restore stability. CRS has no law enforcement authority and does not impose solutions, investigate, prosecute, or assign blame or fault. All CRS mediators are required by law to conduct their activities in confidence without publicly or prohibited disclosing confidential information. Has no law enforcement authority and does not impose solutions, investigate, prosecute, or assign blame and fault. The CRS conciliators work with state and local officials and community leaders to provide a wide variety of services addressing racial issues and prevent violent hate crimes committed, blah, 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 blah. I don't know. I think it's worth a shot. Let's see what they say. You call them and ask them. They have conciliatory powers, right? That's and they're the peacekeepers. I think that there's a lot more to it than just what they're saying here, and one way we find out is put them to the test. Right? You got an ongoing court case, and you have a Civil Rights Act that says you can move the court case, and you'd like to do this, and you're really not sure how, and nobody will tell you. We'll figure out what to ask them, but I just think it's written in the law, and we're not invoking the right law into the right jurisdiction that cares about that law. Because when that sergeant of the police department told Roe, well, state law supersedes federal law, that's when you got to stop and think about, what did that guy just say? State law supersedes federal. Does he really believe that? Because that would mean he believes he can war with the Constitution to commit treason. State law supersedes federal law. I don't think the federal government believes that. And so if you take your complaint to the federal government, well, they can invoke certain powers, like the power of the purse. So we're going to find out. The service may offer its services in cases of such disputes, disagreements, or difficulties whenever, in its judgment, peaceful relations among the citizens of the community involved are threatened thereby, and it may offer its services either upon its own motion or upon the request of an appropriate state or local official or other interested person. Just because you ask, they can get involved. So I think we should at least ask them to get involved and see what they say. So, and then other than that, it's on to the church to say, hey man, you guys got an error in your records, and if you were to fix your records in the church, then because you have these treaties with the state, when you fix your records, they would fix their records, or it would be reflected in their records. On to that one next. Alright, that's where we are today. Thanks for watching. See ya.